because they've already been approved by the Supreme Court. That's what this court told us. And so that's where we went to.
So what do we do? Wait.
No.
Wait. What do we do if the law changes? Do I go back to 1986?
No, Your Honor.
Okay.
You do not, without using common sense.
But that's, you know what, common sense, come on. I mean, it's not okay, come on. I mean, using common sense, what does that have to do with? All right. And let's go ahead and set forth our appearance.
Will Kemp, Pepperman, City Parker.
Joel Odou, Calkins for Rural Water Entities.
Scott Rasmussen on behalf of Hanna Instruments.
Elizabeth Lowell on behalf of Milwaukee Instruments.
All right, I think we left off with punitive damage, right?
That's correct, Your Honor. Your Honor, I show pages 49 to 54 that we had reached an agreement on those, but maybe I'm speaking out of school.
So, do we have, what about page 47, 48? No?
I think those we decided that we were going to have to massage some further. Good morning.
And I just have, one thing I noticed in the instruction on page 47, punitive damages, are those the three areas: malice, oppression, fraud?
Yes, Your Honor, those are from the stock.
What about conscious disregard?
That was proposed by Mr. Rasmussen to be included, and we have no objection to that.
And the only reason I say that, I'm just following the statute. And here's what's important to remember. There's an old law change, we can agree to this, right? As far as the standard book is concerned, in 1986, remember, that was before countrywide. Yeah, and here's my point, because, you know, if you look historically, when it comes to punitive damages, before countrywide, the cases were all over the place. And what Perigary, to his credit, he said, you know what, we gotta harmonize all these cases. And he said, this is a statutory grant, all right, when it comes to punitive damages, that's statutorily defined. And he said, we don't need to look at all these cases, look to the statute. Isn't that what he said, basically? That's what he said, you know, and he was right.
So
So anyway, that's why I just brought it up. That's all, just the statute. You decide what you want to do. If you agree what you want to do, that's fine. That just jumped out at me. That's all when I looked at it.
So, yeah, I think the statute now
I'll let you
says.
guys work on it.
Okay,
Whatever you agree to, I'm fine.
all right. I you know, that Mr. Kemp raised that same issue with me, and I think you guys are both right on that, but I'll amend that and then confer with the defendants on it, and then the other issues we can talk about and then raise any disagreements with Your Honor after that.
Judge, I wasn't right until you read it.
He never is until he is.
But I mean, it's the statute, right? Isn't that what they talked about? In fact, countrywide was about the quote.
I think you were taping our conversation on something.
Yeah.
Well, I tried
Thank
to
you,
be,
by the way, because now I'm never going to hear the end of this for the rest of the
right? I mean, the red flags, right? Why not? You know, I mean, I do try to keep abreast of the case law. You know, but anyway, whatever you agree to is fine. So what do we? I guess we have. Do we have an agreement on page 49? Yes.
Your Honor, I think we have from 49 to 54, but maybe I'm speaking out of school. I think then we just got to do the contested ones, but
All right.
I'll let Mr. Pepperman double check.
That's correct, we agree on the rest. I think everybody agrees on the rest.
So for the record,
Let me just Give me 1 second, Your Honor.
Yeah, we should just walk through them one by one.
That's what I'm going to do, walk them all one at a time with you. Is that okay, Mr. Rasmussen?
Yes, Your Honor, I just want to go through them, yes.
Yeah, that's what I'm going to do.
Yes, Your Honor.
And we'll start
Thank you.
with page 49.
Thank
Is that the
you.
one we're starting?
Yes, Your Honor.
Okay, clear and convincing. Take a look, Mr. Rasmussen.
So that's the 2018 version, and I'm trying to remember, if there is one in the 1986 version.
And I will look right now.
I don't believe there is. I could be wrong.
I don't think there is either, so
Interesting later.
Let's go with the CEO and the document.
After that,
You gotta try it.
You know, it's funny. Let's see what it says. Well, I think what it is under the Nevada County jury instructions, they have a separate instruction for conscious disregard. But it doesn't matter, it's one of the 4 potential bases for it under 42.001. And here's my point, you know, if you go back in 1986, it was all over the place.
And yes, Your Honor, Mr. Rasmussen brought up the 10.21, which is the conscious disregard definition.
Right.
And we have no objection to that. I'll just look at the statutory definitions to amend the punitive damages instruction. And to the extent it doesn't incorporate that same definition, we'll include 10.21. We have no objection to it.
I understand, you want to just get it right. Let's do that.
yep.
So we're looking at right now to see if there's a definition of clear and convincing evidence in the Blue Book, right?
Yes.
And that I don't know. So we'll find out. Yeah, I can see why it's not here. And it's because under the 86 version, with the state of the case law regarding punitive damages was in flux. And so they have down here preponderance of the evidence we can't use. So the question is everyone in agreement with the clear and convincing evidence that was taken from the 2018 book?
I'm fine with it, Your Honor.
yes, Your Honor.
Milwaukee's fine with it.
Yeah, yes, Your Honor.
Okay, I'll put a check mark there. Next up will be page 50, all instructions not necessarily applicable.
We agree with that, Your Honor.
We agree.
We agree.
Mr. Pepperman, is that, I assume you agree these are your proposed instructions?
Yes, Your Honor, agreed.
Then after that, we have the duty of the jurors to consult.
No objection.
We agree.
No objection.
Plaintiffs agree.
Readbacks,
No objection. We agree with it.
Blue water agrees.
No objection.
Plaintiffs agree.
there's a problem. This is somewhat problematic in today's day and age. I used to never bring this up when I had a court reporter until she retired. And we rarely have readbacks, I mean, we don't, but,
We do have a daily though.
pardon?
We've been keeping it daily.
Okay. You guys are keeping dates?
Yes.
Any objection?
No, Your Honor.
Okay. Next up, page 53, that's pattern instruction, 11.03, arguments of counsel.
We agree.
Blue water agrees.
Milwaukee agrees.
Plaintiffs agree.
Okay, moving on, we have 11.05. And that's concluding instructions.
We included the pattern instruction 11.05, which is the including instruction regarding a special verdict form.
Yes. Everyone agrees, I didn't.
Milwaukee agrees.
Agrees.
What we need to do, and this is what I need for the jury, I need, we don't need the headers.
Oh, yes, Your Honor, I put those on just for the benefit of these discussions. The final version will be modified so there are no headers on them.
And no.
And no sites, yes.
All right. So where do we go next?
Which one have you got? Haven't done.
Your Honor, there's some disputed ones, but there was one that Real Water offered that I don't know if, I think it probably was not included, but upon reflection, I think it should be included. It's standard instruction 2.10, witness interviewed by attorney. After some of the recent events, we think it's prudent to have that instruction given.
I thought we discussed this and agreed that none of the attorneys interview witnesses.
Yeah, we don't have any objection to it conceptually, but we didn't think there were any facts that supported it.
We think there is now.
Which one is it?
Just some of the testimony, the witnesses have acknowledged that they've talked to their attorneys before giving testimony. I just want to be cautious.
Yeah, we're not.
Talk to their attorneys?
Yeah.
We don't really object to it, but we think it's factually applicable, but if you think it is, we have no objection.
Milwaukee has no objection.
No objection.
Yeah. Thank you. So next in line, where does that go?
So then I think the disputed ones are pages 22 through 34, but I'm not sure if we
Let me circle
agree on
back.
22. And almost all of these have to do with immediate defendants.
In addition, I would just like to note that Milwaukee offered an instruction on superseding cause. We didn't really get a chance to make a record when.
And we will, ma'am. In fact, please make sure we do that and make sure it's tempered and marked for the record and all proposed instructions that were rejected. I don't think I formally rejected it yet. I just haven't had a chance to look at it and make a record, right?
Okay.
So anyway, and we'll handle that in this batch. So as far as we've taken care of the uncontested, and where did we leave off? Remember?
I thought it was page 22.
Page 22, I think we agreed on.
Yes.
That's a stock. Page 23, we agreed on. Yes, we left off on page 24. That's what I got.
Okay. We didn't talk about stack lids?
He started, and we segued out in squirrel days.
As one does.
Yeah.
Okay, let's go back to page 24. Stacklets. All right.
What is it in
Or we brought it up and it had been.
No.
Okay.
It just says in the agreement.
All right. So where did we leave off as far as page 24?
Yeah, Judge, as we pointed out, this comes straight from Stacklitz. And, you know, I think especially when we have the CEO of Hanna testifying that he doesn't know what you need to do or how this oxidization works himself, why should we have to prove a specific defect? And so I think it's particularly apt to this particular case. And that's without getting into the squirrel at this point. And we don't want to have a jury sitting there thinking, oh, Mr. Kemp didn't prove that the platinum tip was 1 millimeter off or whatever. That's what, and if it was the case, but we don't have to prove that.
I think that Mr. Kemp's thoughts about what Mr. Salvazio testified as to on how to oxidize the probe is not correct. And that the Stacklitz case has to do with a product defect about a Nissan motor vehicle. This is a failure to warrant case, and therefore we've already said that this is not applicable to this case. This court has said several times it's a failure to warrant case. There will be court even said there'll be 2 different experts who will probably testify with regard to this. They'll have their expert, which was Dr. Motley. He came on, he testified with regard to the tip card. And then we'll have our expert, Dr. Fortenbaugh, who will come on here and testify with regard to his findings. So with that in mind, I don't see how this particular jury instruction has any bearing in this case. It's irrelevant at this point.
Judge, failure to warrant of what though? That relates specifically to the product. And the way the jury instruction reads is that it's unreasonably dangerous if they don't warn of a potential defect in the product. So this is saying that I have to prove a specific defect, okay? And we don't have to do that.
Your Honor, Milwaukee objects to it as well, basically for the same reasons. I'll just briefly restate them. This is an inadequate warnings claim. It's not about a unreasonably dangerous claim. And in this case,
Well, there's
there
all
was,
unreasonably dangerous under the restatement of torts 402A. It just comes down to whether it's a design, was that the danger? Was it the manufacturing, was that the danger? Or was it the improper warning, is that the danger?
Right.
and part of the language that comes right before this talks about, oh, we don't need to talk about a defect because there was an unexpected, dangerous malfunction. When machinery malfunctions, it just obviously lacks fitness, is what the case is about. There's no unexpected dangerous malfunction.
Well, Judge, I think this leads us right into the squirrel case, which expanded upon the Stacklitz, true in the breach of implied warranty context, but the Supreme Court in Squirrel said, quote, applying this reasoning, referring to the Stacklitz reasoning, we conclude that it is too burdensome to require a plaintiff to prove precisely why a product does not work, specifically in instances such as the one presented here, where a product integrating electronic and mechanical components is involved. So they want to get up there and say, oh, they've got to prove a specific defect that we had to warn about. That's just not the law, okay?
And I think that the concern especially is here because of all the different testimony about the amount of time on the oxidation. Even witnesses said, oh, minimal 2 days, 4 to 5 days. It can't be held against the plaintiffs to prove whether it's 2 days or 5 days or that if 5 days is even effective because that's a specific defect. We don't even know that 5 days in vinegar is effective.
And I haven't heard all of the witnesses as well yet in order to make a determination. But again, this is a motor vehicle case. It has to do with a malfunction in the steering column of a Nissan motor vehicle. Appreciate that it goes up to the Squirrel case, but if it goes past this 1984 case up to the Squirrel case, why don't we have some language from the Squirrel case as opposed to the 1984 case, which clearly is talking about a malfunction, and the Squirrel case, if it has to do with warnings or instructions or something like that, then that's the case that should be brought in this case.
Well, I mean, it's not, I mean, if you look here, they cite Guinness, and here's my point. They said, this is what the Supreme Court said. They said in Guinness versus Mapes Hotel Corporation, and this is straight out of Stackelwitz, we extended our ruling in Shoshone to designers and manufacturers of all types of products. We further determined that a plaintiff established sufficient cause for the jury that a product was defective by showing that it failed to perform in a manner reasonably to be expected in light of the nature and intended function, and was more dangerous than it would be contemplated by the ordinary user having ordinary knowledge available in the community. And the reason why that's important, that's basically tying up or tying in a consumer expectation test. That's what that is, right? Isn't that what that's doing?
That's exactly what that is.
And so, if you're taking it that, you're saying that they have to establish a specific defect in a failure to warn case, I don't see where that comes from. Because at the end of the day, the product failed, that's the allegation, and we've had significant testimony as to the failure of the insufficiency of the warnings in this case. And I understand ultimately the jury's gonna decide that. And so the bottom line is the product failed, right? The allegation is the product failed.
Oh, the allegation is, yes.
Yeah.
Okay.
I mean, and here's the failure. The failure is based upon the insufficiency of the warning. That's the allegation
Okay.
in front of the jury, right? Because remember, when you talk about products liability, I know I keep coming back to this, but this isn't a design defect case. It's not a, quote, manufacturing defect case. It's a failure to warn case. And at the end of the day, in a failure to warn case, the simple fact that there was a failure is sufficient to get in front of the jury, and you don't have to argue as to, well, this is what happened, or that's what happened. What failed, right? And at the end of the day, this all ties into the consumer expectation test, and this is why our Nevada Supreme Court rejected the restatement of torts third, 402A, because they felt that was too burdensome. Am I missing anything?
No, Your Honor.
That's what happened. They rejected the, what was it, risk utility, something like
Risk
that?
utility, and that was Ford versus Trejo, and that
Yeah.
was Justice Stiglitz, and that was 2 years ago, I think.
Right. I mean, they summarily rejected that. And there's public policy reasons for that. And Justice Stiglitz did a pretty good, I don't have the case right in front of me, but I read it, and she did a pretty good job of it.
And that was a big decision, Your Honor. There were dozens of amicus briefs. It was a highly contested issue.
I would think probably. You know. So, I mean, I don't even see, though, I said, plaintiffs do not need to prove a specific defect to prove that the product failed to perform in a manner reasonably to be expected in light of the nature and intended function. You know? That seems to me that kind of mirrors the consumer expectation test. So anyway, we have a good record. We gotta move on. I'm gonna give it. What's next?
Go ahead, I'm sorry. This is a warnings one, but it's,
No, what page so I can follow this?
you're on page 25, right?
Okay, let me go.
Chapter 7, the 1986 jury instructions.
So I'm on 24, 20. Page 25, right?
25, Your Honor.
Okay, I'm with you.
what's already been approved by the parties is 7.02, the elements required in order to do that, which includes failure to warn. Then there's also 7.03 and 7.04, which are not being used because they go over design defect and manufacturing defect. But 7.05 is being used. So we already have a jury instruction on warning defect definition. It's already been approved by all of the parties. So then we have another one on this same issue that's being proposed by the plaintiffs from the 2003 case of Lewis versus C. Ray Boats, Inc. I believe it would be confusing to the jury to have two different jury instructions on the same issue, and there's no need to have two different ones. The warnings defect, that is 7.05, in the 1986 version of the approved Supreme Court ones, we believe is adequate.
Judge, this is,
Milwaukee would agree with that, and I'll give you a case site, Village Development Company versus FILICE, 90 Nevada 305, which generally says one instruction adequately covers a given theory of liability or defense. It's preferable that the court refuse additional instructions relating to the same theory.
yeah, Judge, the problem is, what they reference doesn't explain what a warning is or must do. This does explain that. This comes straight from the C. Ray case. If you've got the case in front of you, Your Honor, you'll see that this was the central issue of the case, what you should instruct with regards to the adequacy of warning. And the Supreme Court spent a lot of time on this, and they said, in fact, there are two portions of the opinions in the case that talk about it and so forth. But word for word, this comes straight from that case. This is the standard warning instruction that has been given in every failed to warn case since 2003. You know, I proposed it a dozen times. I've never had anyone even object to it because it comes straight out of the case. So, you know, I don't understand the objection because, you know, the failure to warn reference that Mr. Rasmussen did isn't specific as to what a warning has to do. It just says failure to warn. So now you're leaving it up to the jury to decide, well, what is this warning mean? That would be wrong, and the Supreme Court specifically said that in the C. Ray case, which is good law.
So,
Which is why it's also a pattern instruction in the 2018
I
version.
forgot that point, it's patterned in 2018. And the reason it's not the 86, of course, is C. Ray was decided in 2003, 14 years, or 17 years after the 1986 patterns.
All right. Anything else I need to know?
no, Your Honor.
Well, here's the point, and this is an important point. For example, you look at medical malpractice and the instructions they have regarding standard of care of the physician. There's more than one instruction that's given in a medical malpractice case, right? There is, and it's clear. First, you give the general duty, and then they have one for a specialist, and then they have a causation type. And here's the distinction, and to me it's pretty obvious, and I'll be candid, I don't know why this is being, I think actually it would be confusing not to have a definition for adequacy of warning.
The jury also gets a one about using common sense.
But that's, you know what, common sense, come on. I mean, it's not okay, come on. I mean, using common sense, what does that have to do with the adequacy of warning and what the jury should look at? Quote, a warning must, one, be designed so it can reasonably be expected to catch the attention of the consumer. Two, be comprehensive and give fair indication of the specific risk involved with the product. And number three, be of intensity justified by the magnitude of the risk. That's what the warning has to give, right? That's what the case law says. Then next you have, if you find that the warning provided, and it's saying, look at it, ladies and gentlemen of the jury, look at the warning. Does it comply with this mandate by our Supreme Court? I don't see why this is being opposed. This isn't one of those that's kind of like, you know what I mean? It's
Yeah.
not.
Go to the next one, because there's more than just one, there's like
And
5.
we'll get to those. We'll get to those.
And maybe I should have waited for that and said that, because what we're gonna find is now we have these special ones that all have to do with warnings, and we've got 5 or 6 of them. All in the same thing, and we've already used the one that the court told us in the very beginning when we were creating, or when we wanted to look for jury instructions, please use the 1986 version of the jury instructions that have already been approved by the Supreme Court. And these are the ones that I want to use. These are the ones that I know are the best to be used because they've already been approved by the Supreme Court. That's what this court told us. And so that's where we went to.
So what do we
Yeah,
do?
but-
Wait.
No.
Wait. What do we do if the law changes? Do I go back to
Agreed.
1986?
No, Your Honor.
Okay.
You do not. I agree with you on that.
So, Your Honor, the next one is.
Wait. I just wanna, before we go, one second.
Oh, that's true.
This is it. Look what the Supreme Court said in C-Rank.
Just what I said, Your Honor.
They say here, the district court's warning instruction provided very little in the way of guidance, other than to generally state whether a warning is legally sufficient depends upon impressions that the warning language is calculated to make upon the minds of an average use of a product, period. Comma, close quote. And the jury should use common sense in resolving the issue.
We agree?
And that's my point. Okay. Let's move, so as far as page 25, I'm just checking it off, I'm getting. And then, I don't know if this page 26,
Yeah, Your Honor, let me explain the genesis of this, because I'm assuming there's an objection, I don't understand why. Under Rivera versus Philip Morris, the federal court, or I guess, actually it was a question certified to the state Supreme Court, they rejected the idea that there would be automatic heating. In other words, in a failure to warn case, you would just assume that the recipient of the warning, whoever that is, would have heeded the warning. Some states have a heating presumption, they call it. So that was the issue in Rivera versus Philip Morris, and that case went back to the language in the General Electric versus Sims case and adopted that. And that language is not as strong as the language we have here, acted in accordance with the warning. I can't remember exactly what it said, but it was kind of watered down. So what happened is when we got to the Chiavani case, Mr. Colsenberg and Mr. Henriot, somehow or another, it was like 11:30 at night, talked me into agreeing to this instruction. And so this is word for word, would have acted in accordance with the warning. So that is stronger than I ordinarily would have agreed to, but they talked me into it. And then it went up on appeal in Chiavani, and the court affirmed this as an appropriate warning because there was an argument made in that case that the verdict form had to have causation language in it too, and the Supreme Court held that this language alone was adequate to instruct the jury. So this is actually slanted more towards the defense position that I think you could argue was justified under that General Electric versus Sims case.
Well, actually, I have the Rivera case right here, and what it says is, Further, the burden of proving causation can be satisfied in failure to warn cases by demonstrating that a different warning would have altered the way the plaintiff used the product or would have prompted the plaintiff to take precautions to avoid the injury. So,
Right, that's the watered down language, Your Honor, and that's what we typically propose. But I proposed this one just because, the Giovanni case approved it, number one. And number two, I don't want any issue on causation at Supreme Court level. So I've already proposed a stronger one than I think they're really entitled to. And I want to hear why they're objecting to that. And if defendants want to go back to this Rivera language, which is the Sims language, I'm fine with that too, Robert, because I think that's lessens burden a little bit on plaintiffs. But whatever they want to do.
Okay, what do you want to do? Is there an objection? That's my question.
The objection really is the same one that we've been saying, there's quite a few. The language on this one, obviously is new, it cites the Giovanni case, and that's great. Again, I don't believe that case is on point, but having said that, I think we've now got this one, the next one, the next one, the next one, the next one, there's 5 or 6 more, all on warnings. And I think Ms. Lowell has already told the court from one of the cases, that when one instruction will be sufficient, we're fine. So my only objection is, I've got 6 specific cases when there is a warning one in 1986, we agreed to it. You've now added 2 more. I guess there's going to be 6 more that they want in after this. And do we need to have all of those? Because I think that what's happening to the jury being confused is, well, the court's given us this law. It must be that the court already believes that there's a problem with the warnings. It gets to be too much. And I don't know that it's fair because it highlights this with that sort of a situation. And I think where one is there, we get away from that prejudice that can come to the defendants.
Judge, if the defendants want to take the position that I won't have to prove warning and causation, I'm fine with that. Okay, but I want it clearly on the record as to why this instruction wasn't given, because I don't want to appeal them to say, well, Mr. Kemp didn't prove warning causation. Because I'm agreeing to an instruction that's stronger than would ordinarily be retired. But if they want to say that I don't have to prove this, I'm fine with that.
And that would be Milwaukee's position too, that they're, it's somehow confusing and prejudicial because there's too many. If we could possibly rework them into something that's closer to 1 or 2 longer, I don't know the answer. It's just the concern is the number of instructions, one after the other, defect, warning, unreasonably dangerous, like over and over and over again.
Your Honor, that's a lot. I mean,
I'd
be concerned not giving this instruction.
Wait, here's the thing. At the end of the day, all I want to know is I'm looking at this instruction, warning, causation, and where it comes from, Giovanni, I understand its origin, and I just want to know if this is an appropriate instruction or not, then I'll move on to the next. If we get 3 more down, you might say, well, Judge, this is duplicative of the prior instruction. That's fine. But my point is this, there's many cases involving complex litigation. And like I go back to medical malpractice, you just don't give one medical malpractice instruction. You have to have standard of care defined. You have to have deviation from standard of care. You have to have what if a person's a specialist or not. I mean, and it can kind of go on and on. But for now, I'm just looking at it, and maybe we can combine them. I'm not objecting to that. I just want to know if this is an appropriate statement of the law as it pertains to this case, because it talks about, it says, quote, if you find that the warnings provided by MW 500 or meter were inadequate, defendant Milwaukee and Hanna are both liable. If the plaintiffs prove by a preponderance of the evidence that the individual who might have acted on any warning would have acted in accordance with the warning. So that's like, and there's nothing in here that covers that issue, right? The one before that, it talks about the adequacy of warnings, right? Then the one before that, we have a plaintiff needs to prove a specific defect to prove that a product failed. So I'm trying to figure out where we're going, because, I mean, I do have cases where I have a clear disagreement based upon judge. That's not the proper law. This is the proper law. I get that.
Your Honor, let me answer your question on that one. This is the proper law. The question is that I have, and we'll get to more of them as we get through this. And I guess I'm just explaining to the court ahead of time where we're going to get to where I think they become cumulative. This is the proper law. Do we need this, or does the jury already understand this by the time we get to the 5th, 6th, 7th, 8th failure to warn law, or are we just being duplicative? This is the law, I get that. Do we need all of them, is where I'm getting to. And I think I've tried to, never mind, I got cut off.
Listen. Because, I mean, I understand how the lawyers might feel, but I don't want to tell you this. I don't want to try this case again.
But Judge, that's why I said, if they
I
don't
don't want
want
to
to
try this case again.
yeah, if they
I
want
mean,
warning causation instructions.
I
like that,
respect, and on a personal level, I like everybody in this courtroom. But I don't want to see you again on another trial for 6 weeks, and another 6 weeks plus of pretrial motions. I'll be candid with you. So my point is this: when I approve the jury instructions, I want to make sure they're sound, and I don't have to see you again, right? I don't like saying that.
Okay. So our position is that, yeah, this is the law, we get that. We think that there, as we go through all these, they become cumulative.
Okay, I understand. However, now, just want to make sure I understand where everybody's at before I make a decision as far as page 26, the warning causation. Is the plaintiff still offering it? Is the
If
defense
Judge, I'm offering
objecting?
it, but as I said before, if they want to take the language from Rivera, which is a different warning, would have altered the way the plaintiff used the product, or would have prevented or brought the plaintiff to take precautions to avoid the injury, I'm fine with that too. The user rather would be user. I'm fine with using that one or this one. This one, the way I read it, it's a bigger burden on the plaintiffs, but I'm fine with using either one they want.
If the court is inclined to use one of the versions, we would want the Kiwani case. Thank you.
I'm not, number one, I'm not inclined to do anything.
Oh, I'm
First
sorry.
and foremost, no, it's true. What I am inclined to do in this regard is, if the plaintiff's proffering a specific instruction and the defense is objecting to the instruction, I need to know the basis in law. I mean, and if this instruction is a proper statement of Nevada law, and it deals specifically with the adequacy of warnings, I have one or two choices, and it's been offered. Accept this instruction here based upon Kiwani, and/or maybe an alternative based upon Riviera, if you can't agree. Now, if the defense is taking a position, Judge, we only agree to Kiwani, then we'll move on to the next one. This will be accepted. All right, let's move on to the next one. I'm on page 27.
Because the intent of this instruction is to avoid arguments that, oh, we did everything we could have, we exercised all reasonable care, so we're not liable. That's the intent of this. And the other thing it accomplished is it hooks the distributor back into the defective product. So this comes straight out of Ford Motor Company versus Trejo. We talked about the case. We quoted, you can see the quote there, direct quote. I don't understand the objection.
This one has more to do with the fact that I believe it was Dr. Motley's already testified that this is not an inherently dangerous product, meaning the MW500. If this is intended for the real water product, I could see where this could be used.
No, it's not intended for real water because there's stipulated liability. It's intended
So that's what I thought. So I don't see this one as being more than confusing to the jury as to why is the MW500 meter inherently dangerous as a product. This is a failure to warn case, and this doesn't speak to that. This speaks more to, we have a defective product that's put into the stream of commerce, but doesn't speak to the failure to warn, which is what we've seen till now. Now we have something else that I think will be confusing to the jury, because we don't have a claim for a design defect or manufacturing defect, and yet we have those particular terms used at least twice in here.
But it doesn't really say a manufacturing, design defect, or any of those things. Because at the end of the day, we have to remember, in strict products liability, who is potentially liable.
All of them, Your Honor, I agree with you.
Right.
But this is about a defective product. The product itself is causing the harm. Here, it's that the warning was inadequate.
That's still a defective product.
I'm not-
It's a defective product.
That's why I think the disconnect
I get it, but
is.
we've already, that's the point, is that we've already had 3 or 4 now warnings, jury instructions, and now we have another one that appears, from my review, from the Ford Motor Company, which is again a motor vehicle case, the Shoshone Coca-Cola, which again is about the product itself, and doesn't have to do with the warnings on those. Now, do what you want to with it.
Coca-Cola is a bottled water product, or a bottled product.
We don't make a bottled water product.
A bottled product, bottled Coca-Cola product.
I agree with you. 1966, I see it. Anyways, so our objections that we're down into, is this cumulative? Could be confusing? Why do we have another one? Those are my
I
arguments.
can tell you why.
Okay.
That's by reading the instruction. All this instruction is essentially saying is this: look, ladies and gentlemen of the jury, you make a determination as to whether or not the product is a defective product, unreasonably dangerous. That's what it says, right? And you're to discard any issues regarding what we did all we can did or what we did wrong, because reasonable care is not a defense in this case. That's really and truly what it's focusing on. I mean, this goes back to McCourt versus J.C. Penney's. That's what this goes back to.
Great case, Your Honor.
I was a young lawyer. I was under 30 then, I will say
I
that.
think I was only 32 year old.
Yeah, that's what this goes back to, right? And it was Mr. Goldwater was trying a case, and what Mr. Goldwater said during the case and was regarding sleepwear sold by J.C. Penney's, and it had been used, and there was a question as to the consistency of the fibers that were used in the sleepwear, and it wasn't flame resistant. And the bottom line is, during the defense of the case, Mr. Goldwater stood up in front of the jury and said, ladies and gentlemen of the jury, what did we do wrong? We didn't do anything. We just made up, which is an improper argument, right? And that was back in 1984, 83, 85, something like that.
It was a good improper argument because I think he won the first case.
You won the first case,
Right.
that's right. And then the Supreme Court said, no, you can't make that argument. You know, I worked on it post-trial. You know, that's my point. You know, but that's what happened. And so when I'm reading this is what this instruction is saying. It's saying, look, when a manufacturer, distributor, or seller has placed a dangerous or defective product into the stream of commerce, the manufacturer, distributor, and or seller are all strictly liable for any harm caused by the dangerous or defective product, even in those situations where the defendants exercise all reasonable care. And the point is, the thrust is not on what they did or did not do wrong. The focus is on the product and whether it's a defective product unreasonably dangerous. It can be based upon design, manufacturing, and/or failure to warn. So we made a good record. So I'm gonna, and
I
so,
do think it's confusing.
Go ahead, ma'am. I'm sorry.
I do think it's confusing that, because there are two products in this case. And I understand, there is instructions earlier on saying like real water is already admitted liability, but when you take out, I'm just not sure. I mean, there are two products, and when you make it just a generic, dangerous or defective product, does that
I don't
confuse
mind
the,
adding of meters after seller.
say that again?
helps.
What will?
If you say when I manufacture trigger seller of meters, I don't mind doing that. That helps.
ORP meters?
Yeah, ORP meters is better.
I think that would possibly clear up confusion. I just, there are two products, it could be confusing.
I have no problem doing that.
Okay.
okay, so where do we put it?
I
What do we
would, I would
put?
put right after the word manufacturer, sugar seller of ORP meters as placed. Just add that in there.
Okay, and, I mean, that's noted, everyone agrees, that's fine. I'll put it, I'll approve it. And I understand the concern about making sure the jury isn't confused as to who this applies to. I get it. All right.
You know, in the preceding one, Your Honor, we used the term MW500 or meter. I think we ought to keep it, I don't care which one.
Keep it consistent no matter what you do. Ma'am, what's your recommendation, ma'am? Is that fine?
In 3500.
MWB 500 ORP meeting.
That's what it'll be. And that's MW 500 ORP meter now?
Yes.
All right. Everybody note that?
That's fine with me, Your Honor.
Okay, let's go to the next one.
This is the foreseeable misuse issue. I don't, and I think we've shown this as a matter of law because we have a testimony from J.C. Brown, which we can queue up if we need to. It says he knew 1/3 of his users were using these meters to make alkaline water. How can there be it's not even a misuse, it's a foreseeable use. As a matter of law, it's a foreseeable use.
So they were making conjugate water, which is negative ORP water.
Con is just 600, 800, and real water was 200, 300.
No, it's electric, it's an electrolysis process, it's not an alkaline process. Alkaline has to do with chemical compound of the water. That's why I had a real struggle with putting all this conjugate stuff in here, because it's not the same thing. Remember, conjugate doesn't use any chemicals. And this clearly
not true.
conjugate does not use any chemicals. I'll
Are
say
we
it
on
again.
the, but here, I don't want to cut you off, are we on the same page? Because I'm looking
We're
at
on
page
the
20.
28, Your
Yeah. We haven't got to 30 yet, right?
No,
I'm on 28, right?
I'm on 22. Did I say 30? I apologize if I did.
You're on 22?
I'm on 28.
28.
28, great.
28, yeah,
Okay.
that's where I am, Jim.
Okay. The argument for this one, and again, this is also from the same sources before, the Lewis versus C. Ray Boats case, which we've already had one instruction that's come out of. I think it's cumulative.
Tell me why, because I want to make sure I understand your position, that's all.
So we have one, page 25, warnings, adequacy of warning. We have privacy system obligations provided to products with warnings that adequately communicate. We have the first one on page 25, a warning must be, and this is what it gives the definition. And we have this one. Let's just add more stuff to this. Adequately communicate any danger that may result from product use or foreseeable misuse. We already have a bunch of this language already in on page 25. I don't know that we need another one on the exact same case.
When we look at 25, show me where it says foreseeable misuse.
be designed so it could reasonably be expected to catch the attention of the consumer. And you cited the Lewis versus Seabury codes, be comprehensible, give a fair indication of the specific risks involved with the product, be of an intensity justified by the magnitude of the risk.
It doesn't say anything about the risk.
And by the way, there's been no evidence that we delegated the responsibility for assuring the product is dispensed without proper rights. There's no delegation, there's been no evidence of that, so that part of this instruction is not relevant to this case.
What about holding up the box and saying this is approved by the CE? You didn't think that was an attempt to delegate it?
And yet, it wasn't allowed, was it?
No, but that doesn't mean you won't try to enclose it.
Your Honor, this is the only one that actually expressly discusses foreseeable misuse. That's why it's important.
I just pointed out to Mr. Kemp, I think it needs to be changed a little bit. It should say product manufacturers, distributors, and sellers have an obligation, because that's a true
Should be the
statement
same
of
as
the
the
law.
last one.
That should be the same as the last one. That's a correct statement of the law. And there's been, I don't know how many arrows Hanna has shot at Real Water in terms of their use of their ordinance. So certainly, the evidence in this case supports this instruction.
Here's my question, I understand it might have to be cleaned up, and I understand, ma'am, I was understanding you, I was listening to your concerns about having too many and maybe some should be combined, right? I'm listening. Here's my point, why shouldn't we take a warning defect, adequacy of warnings on page 25, make that the second paragraph in this one here, and then, because it deals with warnings, it will start out, product distributors have an obligation to provide their products with warnings that adequately communicate any danger that may result from the product's use or foreseeable misuse. Secondly, a warning must be designed be designed so it can reasonably be expected to catch the attention of the consumer. 2, be comprehensive and give a fair indication of the specific risk involved with the product. And 3, be of intensity justified by the magnitude of the risk. Then in the last paragraph, a product distributor cannot delegate the ultimate responsibility for assuring that their product is dispensed with all the proper warnings.
I don't have any problem with that, Joe.
That makes sense, Ron.
I don't have a problem with that except for the last paragraph. I don't see that there's been any evidence
Okay.
that the
Well,
last.
we made some.
I agree, yeah, we have. Sure.
But go ahead, sir.
All I'm saying is that there has been no evidence that the product distributors, sellers, manufacturers delegated their ultimate responsibility for assuring that their product is with all proper warnings. That's a delegation part of this, and I don't believe that's at issue and evidence in this case. And therefore, I don't think that sentence needs to be a part of any warning, or any instruction, excuse me.
Tell me, where's the harm? And this is my point. Basically, what it says there, product distributors cannot delegate. They're talking about a non-delegable duty,
Agreed.
right? That's all they're saying. And so my point is this, what you want to do is essentially this, make sure you instruct the jury on what the appropriate law is, right? Now, no question that, and I agree with you, it was kind of handled, but you never know what a jury will do when it comes to deliberations. And so, number one, I look at it, is it a proper statement of the law? It deals with non-delegable duties. Yes, it is. And number two, how would this potentially negatively impact the jury deliberation process? When you're just saying, look, ladies and gentlemen, this is their duty. They can't delegate it.
Yeah, Judge, I think some jurors have this concept, there's some mythical consumer protection angel out there, looking over them and, making sure all the products are safe, and that's why I would like this.
Well, I mean, I think I agree with that to a certain extent, but I think it's just been my experience when it comes to jury trials, that you want to make sure that you button down all the hatches when it goes to the jury, because, for example, you look at that and you don't know what juries do when they deliberate, but I don't mind saying this in a general sense. This is true. I don't have many trials that come back. And my point, and I make sure the jury's well informed, but just as important, even the one that does come back, that did come back, I still disagree.
Judge, should we try to make it consistent with the changes we made to reference and or meter and 500?
We have to, I think, because you want it to read like a book.
We will try to make it a book.
Good.
Right, I mean. So other than that, I mean, I get we combined it, ma'am, I took care of your concerns. Any objection, because they do need to know that this is a non-delegable duty, right?
No, Your Honor.
Yeah.
No objections.
Yeah. You see what I'm saying, though, but I agree that we gotta combine it, there's too many. And in fact, that's.
You may want to do that same thing with 28 and 29, I mean 29 and 30. You know. I think you can come to that same conclusion or some variation of that.
I agree, if we put along with things, I agree that's gonna be, the last one has to do with latent or hidden, or whether common user knew or appreciated.
And we'll get there,
Before we get there.
Oh, I'm sorry.
No,
Sorry.
we'll get there. I'm like, if you
He was
did
talking
that-
about, so I was responding to both.
Yeah.
You want us to try and add 29 with 28, is that a suggestion?
No, I think we're doing, I just wanna make sure.
Do 25 with 28, or 25
We will
inside.
come inside 20,
First
28
line,
and we'll 25.
existing 28, then we add 25, then we finish with this last line.
Right, that's where we go.
That's pretty bulky instruction.
That's pretty good.
Yeah.
Yeah, I think Mr. Rasmussen and I are on the same page in terms of moving forward, 28, 29 potentially being combined.
Let me see 28.
28 is combined, yes, I thought you said 30. Ted, that's
No,
what I said.
actually, but here's the thing. I don't know if you put that in, but the way I read it, just from looking at the instructions, and I will listen, but I was thinking 25 goes into the middle of 28, right, we discussed that,
Right.
right? Everyone's kind of agreeing on that. Then what do we do with 29? I mean, I don't know.
That should probably come after the first sentence of 28, logically, before.
Okay, interesting.
That would make it a long instruction, but nothing wrong with that. You just gotta take a deep breath.
Okay,
That's the 29's okay, then. What about,
So let's make sure, so everybody's on the same page.
yeah, we are.
No, where it goes. I want to make sure,
so I
the way I'm seeing 25 goes in the
28.
middle of 28, and then in the same 28, the second paragraph is 29. Is that right?
I took the first sentence of 28 and made the second sentence of that 29. Then I moved in 25 and then I finished with the delegation.
Right.
Okay.
So if it's okay, Your Honor, we'll see it at the end. I think it's gonna be fine, but if you'll just give us one chance to maybe look at it. What's actually
I'll give you more than one chance.
That's all.
I'll give you more.
All right, that takes us up to 30, which is the latency, latent paging.
So,
Let me see what this says. All right.
so Dr. Motley, I believe, testified with regard to his understanding that the tip card, there was nothing wrong with what it said, but that he wanted the information in the tip card to be in the instructions, and that was his concern. He acknowledged the tip card was where it was in the box when you opened it. So my question is how is the tip card, if he saw it when he opened the box, latent? Now, I'm going back to because I represented a lot of insulation contractors, drywall contractors, framing contractors. I know what the word latent means, I know what the word patent means, and I don't see that as an issue in this case, and therefore I don't see the relevance of this specific warnings instruction, because that's not the evidence that was presented by the plaintiffs in their case in chief, that we were hiding the instructions, that we were, what does it also say here? That they were latent, in other words, they were behind a wall, which is what we have in an insulation case or drywall or framing case or sometimes plumbing and electrical. That doesn't doesn't work here. And the other one is that it talks about
You
the
don't want,
common.
you don't want this instruction?
What?
No, I'm just asking you, I mean, I'd be candid with you, I think this instruction kind of benefits you, and you're telling me you don't want it?
Again, if this case,
Ma'am, am I missing anything there?
I was looking at it, I thought it might be beneficial.
I think it's good for the defense.
I think this instruction's good for you. I don't mind saying I read it here, and this, my impression is, I don't know why you object to this.
I'm just, again, it was just the same thing. We've got eight different, too many, but we've just combined 3, and that's good.
Ma'am, what's your position?
I'm not objecting to this. I
Okay.
agree though that, we, again,
We'll check it.
You reconsider it?
We're considering to use it.
What was the final vote over there?
I think they're 204.
So we'll give this one. All right.
Oh, yes.
Okay, so the next bunch, can you skip the visual?
Oh, Lord.
and we might as well get to.
We might as well enjoy it. We shouldn't have too much tension.
There's a problem with 31.
You can have tension in
Huge.
front of the jury, but when it's settling jury instructions, we just want to get to the correct statement of the law, that's all we want.
So Hanna and Milwaukee withdrew their objection to number 30. Page 30.
I
Yes,
never
Ted.
made an objection.
Yes. she
The
never
objection
made-
withdrawn.
Yeah.
The next one gets us back to the implied warranty of fitness issue. I don't know how the court wanted to address that.
We have to address it head on.
Okay, well, assuming that we have this cause of action, I think this is appropriate instruction, and we say right here, the court has found one particular purposes was take negative or use while making alkaline water. That's word for word from transcript of court found. That's binding on the jury. It's not an issue for the jury. And so the issues are whether it was fit and whether it was legal cause. And I think that takes us to the verdict form. And if you want to go there, but anyway, I think this is appropriate instruction if you're going to allow it to present that theory of liability.
Here's my question, didn't Mr. Salvaggio yesterday testify that it was something to the effect regarding the fitness for a particular purpose? Did he testify to that, or was that the day before?
I think it was yesterday. He said, I don't know if he used the word fit. What word did he use? I think he did use the word fit.
I'm going to say that he did say the word particular purpose, but it was not in the context of a breach of a warranty.
It never is from the purpose.
But he talked about it in terms of the purpose of the,
I
is
remember,
particular to doing electrolysis, of reading MV voltage. That's what he said.
I remember how it came up, Your Honor. There were the emails that were put up where Mr. Jason Brown said that this was the go-to in one. In the other one, Mr. Brown used the word fit. F-I-T is in the email. And those emails, Mr. Parker confronted Mr. Salvaggio with them, and he said, yeah, it was good for alkaline water, but that was, I think he said, a niche market or something to that effect. That's how it came up yesterday.
Now I can pull up the, my notes from Cross and find it for you, Your Honor.
Your Honor, I just need to make sure that the record is clear. Again, if the court is going to allow this new cause of action to come in, remember, we've heard about this for the first time in June, I want to say 23rd. So the close of discovery is over in this case. There's a motion for summary judgment that gets filed saying breach of the implied warranty of fitness for a particular purpose. You need to know that in the other 26 cases where they've now pled this particular cause of action, they've added facts to their complaint with regard to this. Those facts were not pled in their complaint. We instead have this unreasonably dangerous strict product liability case for the meter itself. And so we've defended with that, okay? And then it became just a warnings case. And then because we says, well, we need to be prepared for this, so we wanted to say, well, Jason And Dr. Jason Babcock is ready to go ahead and talk about testing and about why these meters were not able to be tested because they were spoiled now. We had all this ready to go. And then at this point, we get this. We opposed this particular cause of action. I believe Milwaukee joined in that opposition. We were not given adequate notice in that complaint about anything with new facts that were added in other complaints, with a new theory of liability. There is no word of warranty, breach of implied warranty, particular purpose. None of those words are used in the cause of action. Mr. Kemp believes you've been given notice. I'm just telling you now, this is a notice pleading state, and just because it's a notice pleading state, you know that this new cause of action can come at you. And Mr. Kemp is right when he says, and you said it, we're going to address this head on right now.
Yeah, I mean, we have to.
We have to, and so I need a ruling from the court with regard to that this new cause of action is going to be a part of something I have to defend now as we are past the plaintiff's case in chief, and then we're going, because what the court said with regard to particular purposes, no more, no less, the only thing that's going to be said is this: you even read it yourself.
Yeah, but and when I read, if you go back and look at it, because I looked at it, it dealt specifically with the testimony that one of the particular purposes was Kangen water. Kangen water, right? And 30% of the product was used for that purpose. That was the testimony.
And this is not a Kangen water case, we both agree on
No,
that.
but I understand that, but here's the thing. That's a distinction without a distinction, and here's my point. Whether it's Kangen water or whether it's real water, it doesn't matter. What was the purpose of the ORC meter? What was it to read?
Millivolts.
Negative.
Negative.
Or
reading.
positive. Or positive.
No. What were they using it for? Negative ORC readings, right? And I understand for one, it might have been 600 to 800, and then for real water, they were going to a higher level. I get that. But at the end of the day.
Lower level for real water. It was
It was lower,
actually
he's right.
lower for real water.
Okay.
So if they knew they were trying to get to the higher level,
Yeah, and see,
closer to zero.
here's my point. And
So,
wait, let me finish that, because I mean, I thought about this, and here's the real issue. And I do understand, Rule 12, I understand Rule 8, I understand notice pleading, I mean, I get all that. But here's my point, and it's a simple question. And you say, well, Judge, I can't defend that, but what's there to defend when part of your business practices as it pertain to the ORC meters, 30% of the ORC meters were being used for what particular purpose? And it's to give negative ORC readings. And that's uncontroverted. He testified to that.
okay,
Of water.
I mean, that's a big deal. I mean, it's not just okay, he testified to that.
so I'm not saying that he didn't, but if we had the complaint with that particular cause of action in there at the time that, which was there, that complaint was there before Jason Brown's deposition was taken, would there be something that would have been discussed by Milwaukee with Jason Brown about what that particular cause of action was before his deposition was taken? Could it have been? Could Mr. Robbins have sat down with hey, here are the causes of action. I don't want to say that what Mr. Robbins spoke about with Mr. Brown, his client, because that would be attorney-client privilege, but here's the preparations that would have gone on, here's what they're going to be worrying about, here's what we have to think about is it's an unreasonably dangerous product under strict product liability. Those sort of things would have been done in this case as part of the defense. That did not happen. Instead, we take a deposition, then we pivot for some reason to, we want to go to this particular cause of action now. And so it's not that there was, maybe with the judge thinking, oh, we're going to manipulate the evidence. No, we have to make sure that our clients are on notice. This is what we're dealing with. I told my clients from the beginning, this is a strict product liability warnings case and a strict product liability unreasonably dangerous product case. I have never said that there is some sort of a privity between my client and the real water customers, which we believe is still required to bring about this cause of action. because, and we did address this in the opposition, there is not either vertical or horizontal privity, which is required. There is no contract between us and the plaintiffs. They are not the intended people, we believe, to take care of the MV, the voltage. So I don't see this here for this case. As much as you're saying that there was a blind side, this is a
I'm
blind.
not seeing any blind
I'm not
side. Yeah, I mean,
As much as the plaintiffs have said there was a blind
I
side
didn't say there was a blind spot.
by our witness Laura Brown, because we didn't put in the 16.1 somehow,
Or the interrogatory.
then how is this not a blind side to me with regard to a new cause of action that I'm now defending during trial? I should have had the opportunity to talk to Carl Salvaggio about this, to anyone else there, to talk about fitness for a particular purpose, to make sure that the expert witnesses, all those, understood the law on this particular cause of action. That was not afforded me that opportunity in this case to do so, because we never understood with any particularity of what is going on in this complaint, that this cause of action would become part of the case after discovery is closed. And I'm giving Mr. Kemp the benefit of the doubt, is that the motion for summary judgment he speaks about was 3 weeks after-ish, 2.5 weeks after close of discovery is when we saw this for the first time. And we don't think that's fair and very prejudicial to the defendants in this case.
That's the deadline for me to file that motion for summary judgment, and I filed it on the day it was due, so I don't.
I'm not saying you didn't.
The judge, I mean, the fundamental issue, the notice pleading issue is, if you file a complaint that says it's unreasonably dangerous to measure -4 in alkaline water, and that changes to products not fit to measure -4 in alkaline water, is that fair notice of the claim? And, I mean, I don't think I'm gonna lose that Supreme Court one time out of a million. You know, under a notice pleading analysis, given what Liston says, given what Schwartz versus Adams says, given what the new appellate court case, or the Court of Appeals case said about that towing company, it's notice pleading. Unreasonably dangerous changes, it's not fit, it's the exact same issue. I just don't understand the claim that they could be defending a unreasonably dangerous because it measures -4 in alkaline water. Now they can't, the exact same thing with the words not fit or unfit.
Unreasonable dangerous also has a lot to do with how is the meter used where it was unreasonably dangerous, not for what it did, but for how it could be used that would be dangerous to someone. In this case, I'm sorry, I'll let Mr. Kemp finish.
no, I'm just listening. That's all. I have thoughts and I'll ask a few questions, but I'm just listening.
And Your Honor, again, if that's your ruling, we just need to know what language in the complaint actually provided notices. All of the cases cited by Mr. Kemp, they specifically state in the opinion what the language was that provided notice. And there is no privity. They haven't addressed that. They address it with different claims, strict liability claims. They want to bring a UCC claim. They should address the UCC statute 104.2318 and the cases that deal with that. And in addition, this jury instruction misstates the law, comes from Nevada Contract Services versus Squirrel. That is not, that's a case regarding straight breach of warranty.
And what's the page number?
I'm saying page number 31 of the jury instructions misstates the law for the elements of a claim for breach of implied warranty of fitness for a particular purpose. If you look at the Nevada jury instructions from 2018, and I think we were talking about that on Monday, there was, we all noticed, there are no instructions for breach of implied warranty in the earlier 1986 jury instructions that were approved by the Supreme Court. But we do have these 2018 instructions. It's 7.14. They're different from the elements that we see on page 31, and they cite the statute 104.2315. and they cite a different case, Mahasco Industries versus Anderson Halverson. So I would, if you're gonna grant that motion for summary judgment, which is essentially a motion to amend, then at the very, we shouldn't have jury instructions here for a fourth claim for breach of warranty.
And ma'am, for the record, I understand this, I'm just asking questions. I'm hoping I got the right book here, because I just want to make sure I can follow you. I'll make it easier. Is this the book you're referring to?
I believe we had a discussion yesterday that said in that book, there are no
Okay.
instructions
All right.
for
And for the
breach
record, I'm
of
looking at the
implied.
loose leaf Nevada jury instructions, so there's another book.
Correct. There are no jury instructions for a claim for breach of warranty of implied warranty of fitness for a particular purpose. You know that book very, very well. If I'm incorrect, but I believe that's what we discussed. And we said, oh, here are these jury instructions. It does appear in the 2018 jury instructions. And I have it, it does appear as Rule 714, but I'm comparing 714 in the 2018 instructions with the instructions that plaintiff has proposed, and they don't look the same to me.
Judge Counsel said, if the motion for summary judgment is granted, the motion for summary judgment was granted, all right? There was no reconsideration, the motion for summary judgment was granted. And with regards to the Mahasco case, that was the case over at the then Stardust, I think it was the Stardust. Yeah, it was Stardust. Because the Stardust ordered some kind of fancy rug for the showroom, and the issue is whether or not the seller knew what the intended use of the rug was, i.e. the showroom. Okay. In this case, as we argued in the motion for summary judgment at length, and no one opposed, there was objective knowledge on the part of Milwaukee that these meters were going to be used to measure the negative orb in alkaline water. They recommended this as the go-to meter for that, fit for that. So once you show objective knowledge as to the use, you don't have to show that they knew the particular purchaser in this case, i.e. Real Water, was going to use it. We don't have to prove that. So what she's talking about is elements of proof of a subjective nature that they knew that Real Water was somehow or another going to use their meter to measure alkaline water. We don't have to prove that, Your Honor, because we've already proven objectively that they knew the meter was being used for that purpose. And we discussed this for pages in the summary judgment motion, and they didn't oppose this. They didn't even argue about this. And now they come up at the last minute after losing the motion and say, oh, Judge, we got to decide all these issues again? I just think that's inappropriate.
We
Your
did
Honor, for the bid-
oppose it. We did oppose it.
You opposed the
We talked
motion.
about the,
Yeah, it's
yes,
cheap.
we did.
They didn't
And we
oppose this
opposed
argument,
that
Your Honor.
specific, well, because these are instructions for breach of warranty. They're not for breach of implied warranty of fitness for a particular purpose.
Well, I guess the issue is, go ahead.
Go ahead, Mr. Parker.
Thank you, Your Honor. Your Honor, I did bring this up with Mr. Savaggio, and I just took some time to go pull it back up. But what I wanted to first say is that this issue was raised with Mr. Savaggio January 26, 2023, beginning of this year, 9 months ago. And this is the direct information from the deposition, Your Honor. It says, question, okay, is the MW500 suitable for testing Kangen water? People have used it for testing that. I'm not asking that, I'm asking, is it suitable for doing that? Answer, I've never done it. Question, well, according to this, someone in Milwaukee says it's suitable. Do you see that? Yes. And that would be, and then he says, I've never done it. Question, that would be Jason Brown, who again is the managing speaking agent for Milwaukee. Answer, that is. Question, okay, so as the president of the company, Milwaukee Instruments, would you agree with Mr. Brown that the MW500 is suitable for testing Kangen water? Answer, the meter has been used by people to test Kangen water. We don't exactly market this to anyone in specific. If people choose to use it for this, if they need to get a reading, either positive or negative, the meter should work for positive or negative. Question, for Kangen water or alkaline water, correct? It should be able to work for any type of solution that has AORP type parameter that could be measured. That's it, Your Honor. Back in January of this year, they knew this was an issue. We have questions and answers directly on point. And he said, which we went over yesterday, that he knew, or his company knew, that this was one of the premier, in their opinion, ORP meters used for this purpose. That's his sworn deposition testimony.
All right, and I don't mind sharing this with you, and then we'll just take a quick break. I mean, I see a lot of issues here, but I think it's important to point a few out. And I listened, I didn't even have to take notes, but I listened to Mr. Rasmussen, he said, look, Judge, you know, if you look at this case, for example, Mr. Robbins would have had an opportunity, say if this specific claim for relief was included in the complaint, to address it head on with his client. Well, the bottom line is this, it's like, I mean, I didn't do, I didn't practice in the products liability action. I was more of a general tort guy. And so if I met with my client and I asked him what color was the light, it's either red or green. And there's nothing you can coach them on. There's nothing you can advise them on a fact, right? And we're talking about facts here. It doesn't matter what's contained in the complaint because those are just allegations, right? And they don't become facts until discovery occurs. And here's kind of my point. The evidence under the facts of this case appear to be uncontroverted as far as the use. The use of the meter, we have testimony that 30% of the meters sold were used for the purposes of negative ORP readings, right? That's what it is. And that's uncontroverted. Secondly, yes, I did grant the motion for summary judgment. I was pretty specific, and my point was this. The motion was granted as it pertained to the exact issue we were talking about here. 30% of the ORP meters were being used for the purposes of determining negative ORP readings. That's what the evidence is, right? Whether you like it or not, that's what the evidence is. And so, yes, I granted, if you look at the partial summary judgment and the language I specifically referred to was that specific claim, right? And so from a defense perspective, if your client admits that, yeah, I ran the red light, what can you do about that? You can't tell them not to say that if that's the allegation. You just tell them to tell the truth. And my point is this, it appears to me that we have actual testimony as to the usage of the ORP meters, right? And so there's a lot of ways this can be handled, right? And I thought about it. But I granted the motion for partial summary judgment. Ma'am, you said, well, Judge, that might be akin to granting a motion to amend. Maybe. But here's the thing. You take a look at it, and Rule 15 is pretty clear. And that's why I say we can just address it head on. What does 15B1 stand for?
I don't get it.
But, and here's my point. I thought about all these issues before we walked in today. I had the order that was prepared by Mr. Kemp's office sitting on my desk. I got my notes right there. I've reviewed the points and authorities.
Judge, I think your point is if the facts come into the case, you could amend during the case. We've got way out in front of this, way out.
You get a man jury trial.
Your Honor, if I could just respond to that, the schedule order for this case gave a specific date by which all parties were supposed to amend their pleadings or add parties. That date was March 24, 2023. I'll just say that's in the schedule order signed by the court.
I understand. I do. But that's kind of, and this is kind of where I'm going to, because, I mean, and I don't mind saying this, and I've been told this by a justice, she says they have really good records. That's what they say. I said, they make really good records. And they always know what I'm thinking of, right? They know what's on my mind. I don't mind saying that. And so, okay, now it's time for a break. I told you what's on my mind.
I'm sorry.
Yes, ma'am, I apologize. I haven't made a
Are you
decision.
gonna render a ruling on the requirement of horizontal privity?
Oh, I haven't touched that yet. We'll get that. But here's my
We
point.
don't need to do it before the break.
Oh, I understand, ma'am. But see, that's another thing I have to deal with. I haven't, and ma'am, I'll be honest with you, I haven't looked at that. Okay. But anyway, but I looked at everything else.
Great, thank you.
Thank you, Your Honor.
Let's take 15.